Once again, is Mshamba Marekani. Welcome to All Topics Considered podcast. Obtaining asylum in the United States. There are two ways of obtaining asylum in the USA. Those are through the affirmative process and through the defensive process. Affirmative asylum process with the USCIS. To obtain asylum through the affirmative asylum process, you must be physically present in the United States. You may apply for asylum regardless of how you arrived in the United States or your current immigration status. You must apply for asylum within 1 year of the date of your last arrival in the United States. You may apply for affirmative asylum by submitting Form I-589, which is application for asylum and for withholding of removal. If your case is not approved and you do not have a legal immigration status, you are going to be issued Form I-862, which is called NTA or Notice to Appear, and refer your case to an immigration judge at the Executive Office for Immigration. The immigration judge will conduct a hearing of your case and issue a decision that is independent of the decision made by the USCIS. In certain circumstances, if the USCIS does not have jurisdiction over your case, the Asylum Office will issue a Form I-863, which is a notice of referral to immigration judge for an asylum-only hearing. You may live in the United States while your Form I-589 is pending. If you are found ineligible, you can remain in the United States while your Form I-589 is pending with the immigration judge. Asylum applicants are not authorized to work unless you meet certain requirements. Affirmative asylum applicants are rarely detained by U.S. Immigration and Customs Enforcement. The other asylum is defensive asylum. A defensive application for asylum occurs when you request asylum as a defense against removal from the United States. For asylum processing to be defensive, you must be in removal proceedings in immigration court with the Executive Office for Immigration Review. Individuals are generally placed into defensive asylum processing in one of the two ways. It's either you are referred to an immigration judge by the USCIS after they have been determined to be ineligible for asylum at the end of the affirmative asylum process, or they are placed in removal proceedings because they were apprehended in the United States or at U.S. port of entry without proper legal documents or in violation of their immigration status. Your immigration status. Immigration judges hear defensive asylum cases in adversarial courtroom-like proceedings. The judge will hear arguments from both of the following parties: your attorney and the U.S. government. The immigration judge then decides whether you are eligible for asylum. If the immigration judge finds you eligible, they will grant asylum. If the immigration judge finds you ineligible for asylum, they will determine whether you are eligible for any other forms of relief from removal. If the immigration judge finds you ineligible for other forms of relief, they will order you to be removed from the United States. You can always appeal the immigration judge's decision. So just to recap, the key differences between the affirmative and defensive asylum process. The affirmative asylum process. Individual has not been placed in removal proceedings before an immigration judge. Defensive asylum process. Individual has been placed in removal proceedings before an immigration judge.